May I thank the honourable gentleman for drawing our attention to the judgment delivered on 11th April 2022 by the Supreme Court of Mauritius in the matter of Marie-Ange Brick, born Cale, and the Registrar of Civil Status. The gist of the case, Mr. Speaker, as honourable members of the House may be interested in learning, is that upon making an application in November 27 for a birth certificate in order to obtain a new national identity card, Mrs. Marie-Ange Brick, born on 10th October 1964, was informed that she is, according to the civil status record, registered as having passed away on 5th April 1973 at the age of 8 years old, as her birth certificate was annotated with the mention, quote unquote, deceased on 5th April 1973. Now, Mrs. Marie-Ange Brick believes that her birth certificate was erroneously used to declare the death of her half-sister, Marie Rosinette Cale, who passed away on 5th April 1973 at the age of 8. She was therefore advised by the civil status officer to seek redress before the Supreme Court, which she eventually did. Now, Mr. Speaker, after considering the evidence on record, the judge concluded that the plaintiff was wrongly declared dead instead of her half-sister, Marie Rosinette Cale, and therefore ordered the defendant, that is the Registrar of Civil Status, to, I quote, A, delete the annotation deceased on, décédé le 5 April 1973 in the plaintiff's birth certificate. B, insert the annotation deceased on, décédé le 5 avril 1973 in the birth certificate of Marie Rosinette Cale. C, amend the death certificate, number 10 of 1973 of Béducap Registration Office in the district of Savane, by deleting the names Marie-Ange and the national identity card, the corresponding national identity card, and replacing them by the names Marie Rosinette and the corresponding identity card, respectively. And D, to cause this order to be registered and the relevant entries to be made in the appropriate registers, unquote. Now, it is apposite to note that in the observations and findings of the judgment, the Honourable Judge stated, and I quote, I must at the very outset state that it is a matter of regret that this case took 4 years to be in shape. It must be highlighted that the state is under the obligation, under various international and regional instruments to which it is a party, to see to it that everybody's right to recognition as a person before the law is upheld. See, for example, Article 6 of the Universal Declaration of Human Rights, Article 16 of the International Covenant on Civil and Political Rights, and Article 5 of the African Charter on Human and People's Rights. It cannot be denied that the very enjoyment by a person of fundamental human rights, including his or her access to health care and other services, is predicated in contemporary Mauritius on that person having a valid birth certificate and a national identity card. It is incumbent, therefore, on the defendant and other relevant authorities to ensure that any such application is dealt with on an expedited basis. Now, Mr. Speaker, sir, Mauritius fully ascribes to the provisions of the Universal Declaration of Human Rights, of the International Covenant on Civil and Political Rights, and of the African Charter on Human and People's Rights that I have just quoted and to which the question refers, which all assert the right to recognition of a person before the law. I am informed by the Registrar of Civil Status that there are a multitude of factors that may contribute to delays in the preparation and consideration of such cases, keeping in mind that this process involves, inter alia, and I'll give the examples of the different steps involved. Firstly, the issue of a plaintiff summons to concerned parties by the Supreme Court, including the Registrar of Civil Status. Secondly, the seeking legal assistance from the Attorney General's office by the Registrar of Civil Status upon receipt of the summons. Thirdly, submission by the Registrar of Civil Status of official copies of civil extracts and photostats of registers to the Attorney General's office. Fourthly, carrying out of relevant inquiries by the police department. Fifthly, carrying out of relevant social inquiries by the probation office. Sixthly, identification of witnesses and their availability and evidence of the case. And seventhly, the cases being called pro forme by the Supreme Court. I am further informed at the level of the Civil Status Division that the following measures have already been taken to mitigate and or avoid such errors. In 2001, the civil status database was introduced, a computerized civil status database whereby all civil registrations are recorded electronically. Further, the Section 38(1)(b) of the Civil Status Act of 1981 has been amended in August 2020 so that officers of the Civil Status Office have the obligation to, inter alia, electronically verify the accuracy of the information on the deceased before registering the death. Moreover, Section 50 of the Civil Status Act 1981, which relates to amendment of entries and is applicable in such matters, has been further reinforced by amending Section 3 of the Civil Status Act 1981 in August 2020, in addition to Section 33GA, to cater for mistakes of a clerical, typing, and numerical nature. And finally, the death registration module was enhanced in April 2021, and details pertaining to parents and spouse are automatically pulled from the civil status database, which was not possible before the introduction of the module. Now, Mr. Speaker, sir, further to the judgment in the matter of Marie-Ange Brick-Bourne-Cale and the Registrar of Civil Status, dated 11th April 2022, all concerned parties will be called upon to review the procedures adopted so as to expedite matters in such cases. I have requested the Prime Minister's Office to coordinate this endeavour, and I shall, of course, welcome any other suggestions that the Honourable Gentleman may have.
In the context of that new development from the Prime Minister's Office, would it be considered that pending applications in this case, in such similar cases, consideration be given to exempting applicants from the need to produce their national identity card until the matter is finally sorted out?
Once again, Mr. Speaker, the suggestion is most welcome. I do not know what the actual implications of the suggestion made by the Honourable Gentleman might be, but I shall certainly be pleased to bring it to the attention of the Honourable Prime Minister.
This issue of right to be recognized as person also crops up in matters of tardy declaration. And there's a lot of people, including people, children living in shelters, who don't know who their parents are. And they're having problems when they reach the age of 18 to be recognized because the Ministère Public cannot give a conclusion favorable so that a birth certificate can be issued. So may I also, Acting Prime Minister, also to see with his officer whether there can be a expedited channel for tardy declaration, where, children reaching the age of 18 has to be given an identity card, and through no fault of theirs, because the system requires going through all these court processes, it takes years for them to be issued this ID card.
I fully understand the concern of the honourable member. Fortunately, these cases are less and less frequent, but if the honourable gentleman has any specific case in mind, I shall be very happy to draw the Prime Minister's attention to any such case.